Well, welcome back. For those of you who may be just joining the show, we are talking about demystifying what really happens in a courtroom versus what you see on TV. And we have with us a very distinguished panel. We have Judge Schiffman, we have a retired judge, we have Professor Martyr, who's a professor of law at Kent Law School, and we also have Marty Dolan, who is a practicing trial lawyer and who has trialed criminal and civil cases. Before the break, we were talking about certain aspects of jury selection, and we're also going to talk about opening statements, examinations, and cross-examinations. This is a two-part show, so some of the things that we don't cover in the show today we'll be covering in our second part of the show, which will also include closing statements and jury deliberation. But before we go on to opening statements, I would like to ask one final question about jury selection. And you often see on TV and movies this category of person called the jury consultant. Can somebody tell the viewers, what does a consultant do?
Well, I mean, basically, consultant is hired by the trial team on one side or the other to literally sit there and be next to you at the during the jury selection process to give you feedback as to what juror would be a good juror to select, what would be a good juror to strike off the panel if you have that opportunity, and jurors who would more likely than not side with you based on their background and the very limited time you have to ask questions versus others. You know, some people believe in consultants, some people don't, and many trial lawyers believe that they are very capable of being able to make good selections with jurors on their own based on their experience.
You know, I wonder after a trial when the jurors are interviewed, how close do those jurors match up with what the consultant's intelligentsia, says about them?
Well, my experience is that they often surprise you after the fact, and for a variety of reasons, they turn out to be much different than what you thought about them going in. And there's an old adage that somebody once said, there are two things you'll never know: who a widow will marry and what a jury will do. And it's very difficult sometimes to fathom juries, and it's still a mystery, I think, for most lawyers.
And what jury consultants can't really do is predict how jurors will interact with each other. So you don't know what's going to go on during deliberations. I think if you want to give the best case, at least they serve as a sounding board for the lawyer's arguments and ideas beforehand in preparation for trial. And there may be another pair of eyes and ears during jury selection.
So let's move on to one of the components. Let's talk about, that was jury selection. Let's do another one. Let's talk about opening statements. Could someone maybe comment on how often opening statements actually occur in a real trial and compared to what we see in film? Marty, maybe you could take a first shot at that.
Well, I mean, I think what basically the question asks is how many cases actually get to trial. All cases pretty much have opening statements that are jury trials and often bench trials, but jury trials in particular. I mean, people have to keep in mind, as opposed to what TV may portray, a lot of cases resolve before they ever get to a trial. They're costly, they're expensive, they're tiring, they're all those things. But if they do get to the trial stage, there's a huge amount of preparation in every phase. We talked about the selection and then the opening statement. And in most cases, outside of somebody waiving opening statement, they're made at every trial, either criminal or civil.
Interestingly enough, from a dramatic standpoint, that's probably the first thing they cut out of a movie or a play is the opening statement, because the opening statement is merely, that's how we first tell jurors about the case, what the evidence in the case is going to be. And in a dramatic version of a trial, you've already seen that. You've seen that all information beforehand, so you don't need to know about the opening statement. You don't need to know what the case is about. You've heard that in the presentation, the dramatic presentation. So that's probably the first thing that goes on the cutting room floor in movies and plays about trials.
But Judge, you've adjudicated a lot of trials. How many of them actually get to or cases How many of them actually get to a trial?
You know, that's a very good question, which I'm kind of sorry you asked because I can't even answer it. I don't know. I think rough estimates are probably less than 5% of cases actually go to trial in all aspects. You know, there's a lot of things going on in a courthouse on any given day, but very few cases actually go to trial. You know, maybe even 1 or 2% at the most. It would be a rough estimate.
Yeah, I would agree with the judge. I mean, it depends on the case, but for the most part, under 10% I think is a fair
Yes.
number.
And
You know, that's the I think the difference between TV and
Oh,
movies
yes.
is everybody thinks every case goes to trial, and in fact, the reality of it is very few do.
And the reality of it is, in many cases, it's because the case is very strong or very weak. Those are the, you know, where the stakes are high. If someone is suing for a large amount of money, if the death penalty may be involved, those are the kinds of cases that often go to trial because the stakes are so high. A lot of other cases are very easy to resolve, and lawyers and judges do that all the time.
How much does an opening statement matter? Since you're talking about what you're going to prove, and then, of course, the trial then begins to establish whether you did or you didn't. How much does it really matter, the opening statement?
I mean, I think this goes to what Nancy's been talking about as far as the behavioral part of how they're going to interact. It's the lawyer's first opportunity, essentially, to connect with the jury, to actually establish a rapport, a theme, a consistent theory of where this case is going, and allow the jury to use their inferences, imagination, life experiences, whatever, to start to plug in things as you go along. So it's your chance to give them that opportunity, and then as they see the case progress, they plug in things almost like a Lego tower, and all of a sudden it becomes something. And you give them the pieces, you give them the board, you tell them what's going to happen, and that's what it is. And it goes all down to how they like you, how they interact, how they view the evidence, you know, those types of things.
And from the juror's perspective, it's their opportunity to get a roadmap of the case, to hear what the case is about for the first time and what steps you plan on taking for the case. So it's very important from the juror's perspective.
What about the style of the lawyer who's presenting the opening statement? How much does that matter?
I think it has a big effect. I really think lawyers sometimes forget that when in a jury trial, they're trying to sell a product to that jury of 12 individuals, and the product they're trying to sell is that their client should win the case. I've seen all kinds of lawyers, and you know, here's another area where the drama, the fictional lawyer is not the best, is not really the lawyer in true lawyer in real life. The lawyers who yell and scream and stomp around the courtroom are not the lawyers, I think, who have a good impact on juries. Jurors like they don't like to be lectured to. They don't like to be screamed at. They just, I think they like the better prepared and the nice lawyer rather than the hard ass. Is that I don't know if that's the best. The mean lawyer. The mean lawyer.
So Nancy, are you familiar with any research or feedback from juries who've said, my decision about how I came out was influenced by the lawyer. I didn't like him. I liked him.
Jurors might say that if pressed, you know, they liked a lawyer, they didn't like a lawyer, but they won't say that that's what influenced their decision. That's part of the style, but they'll focus on the substance, on the evidence.
Well, we have really only a few minutes remaining, but I would like, before I ask each of you to give us, our audience, just your overall view about the difference between what you see on TV and in the film and really what happens. Just talk a little bit, though, about the examination process, Marty. What is the purpose of we hear a lot about cross-examination, but it starts off with the lawyer examining witnesses. Can you just give us a little brief summary of what's the purpose of that process? And I'm going to ask you all about your thoughts about the difference between what's real and what's in
Sure.
the media.
I mean, as far as you don't see a lot in TV or movies as the direct examination process. You typically see the cross-examination, pounding the witness or your fist on the table or whatever you want to call it. But in the real world of cases, either criminal or civil, you're prosecuting, you're putting it on, you're the one who has to advance the case. So the first important piece of a trial is the direct examination of witnesses, and what people have to keep in mind is a witness, and whatever comes out of that witness's mouth is evidence in the case. So you are establishing, by way of your direct examination, pieces of evidence along the way, along your path of what you told the jury you were going to do in the opening statement.
So, Nancy, in 15 seconds, what are some of the major differences between what we see in media and what's real?
Well, from a juror's perspective, if they were just watching film or TV program on the jury, they would think that the jury just sits impassively and does nothing else, that that's the sole job of the jury. But in fact, the jury plays a much more essential role and a much more active role, and we'll talk about that some more during jury deliberations, and that's where you really see the jury completely engaged.
Well, you're the spokesperson for a pound on that because we are completely out of town. So, but thank you all for your participation. You're truly experts at what you know and about this whole process. So we thank you on behalf of the viewers. Are so appreciative of your coming in and helping us see the difference between reality and some of the myths that are carried out in the media. Thanks again. I hope you've enjoyed the show. And this is the Illinois State Bar Association.